Yeah, let's start. Good evening, everyone. Welcome to the episode 2 of our webinar series. We had shared the banner for the same, and today's topic, which is scheduled for part 1, is all about the process of bankruptcy as defined under IBC 2016. We had earlier conducted a webinar wherein we have talked about personal insolvency. And today we will, of course, talk about that briefly. And we will talk about how the individual bankruptcy, individual insolvency can be processes which are useful for the individual, useful for the bankers, useful for the professionals. So let's start without wasting any more time. We have this as a 1-hour session. We will try and complete this in time. We will also take as many questions as possible and do that every 25 minutes, 20 minutes. Over to you.
Thank you, Ankit. Of course, this series are really catching up. There are a lot of people, they are showing interest, and thank you very much, all the followers, all the participants. And as we say that our objective is to share our understanding about this subject and also do some kind of creative work. Ankit, I attended one physical seminar yesterday. It was organized by Northern India Regional Council of Institute of Chartered Accountants of India. And it was primarily on the personal insolvency and bankruptcy of personal guarantors under the Insolvency and Bankruptcy Code. So a lot of questions, in fact, was coming, and it was a pleasure for me to answer their questions. See, somehow it figured out that, there are a lot of chartered accountants, a lot of insolvency professionals, they handle the individuals who are under financial stress. They have been struggling as a defaulter. They are not getting fresh commercial start of their life. They are presently listed as defaulter at various financial information companies' sites, and they are not able to become a director. They are not able to own a property because they have given guarantees to various loans. So this is something which is, Ankit, disturbing. This is disturbing to various people, and I somehow started studying, because although our webinar on the insolvency resolution process is already on our YouTube channel by the name of AAA Insolvency. But before I even go for the bankruptcy, I would actually be going through the little bit of recap of the important provisions of insolvency resolution process, because that is something which is helpful for the focus that we are presently doing. Although there is no case of bankruptcy in India so far, and there are about more than 1,000 cases of individual insolvencies who are personal guarantors to any corporate loan. However, the scenario that I'm going to discuss today is that unless we understand the bankruptcy, it would be very difficult to understand the impact of insolvency resolution process. Now, I will share my screen. First, I will share my screen of the earlier webinar which I conducted, and for which the recording is available at AAA Insolvency YouTube channel. But yes, few of these slides where I would like to focus today. And because, see, what I want to say that this insolvency and bankruptcy of individuals is a boon for those people who are under financial stress. So it is a boon for them. See, this is also very important to make you understand what was the intent of government while these kind of laws were introduced. Because I was also member of that committee constituted by IBBI, responsible for implementation of individual insolvency in India. So we had various discussions amongst committee members, and the focus, the rationale for making such law was that it is related to humans. It is not a recovery law. Humans who are under financial stress because of some activities which are non-fraudulent, because of, I repeat, because of some activities which are non-fraudulent and they have never defrauded any bank. So it is for those, and they have a right to restart their commercial life. They have a right to own businesses, to do businesses, to use their experience in the past, and to take an exit from a bad business, take an exit from that bad phase of the life when they incurred some losses. So this is the focus today, that Ankit, we are saying that this is primarily a boon to those people who are struggling. And in fact, what I'm trying to say today, and I will present before all the participants the relevant provisions which actually are more relevant to understand how it is a boon for individuals who have given any guarantee to any loan. So this is, let me quickly go through the past, that particular screen, which are, so this, in fact, this has already been spoken about, this has already been delivered. However, we are just going to focus on couple of definitions and couple of provisions. So what is a personal guarantor? That's very, very important. The definition of personal guarantor is a debtor who is a personal guarantor to a corporator, and in respect of whom guarantee has been invoked by the creditor and remains unpaid in full or part. So first of all, the creditor is not defined whether it should be an operational creditor or a financial creditor. This is number one. Number two, it should be a guarantee given to any creditor. So now what my understanding is that the guarantee can be given to a landlord also, for while taking a property on rent, and the guarantee can be given to a supplier also while taking some goods on credit. So any kind of guarantee is something which is applicable here, and it should be a guarantee for any kind of credit which is extended to a corporate debtor. That's the focus, number one. So jurisdiction and all that we are not going today. We are only adjudicating authority, jurisdiction. That's all. It's not relevant today. So what we said, that there is no process of directly going to the bankruptcy phase. It has to go through an insolvency resolution process phase.
And the insolvency was, and in a summary, I think the insolvency resolution process was all about the idea that you understand the assets, understand the liabilities, and see in case there can be any repayment plan which can be made so that the creditors kind of resolve their debt issue. Right? That was in a summary how the CIRP process happens, that you're looking for a resolution. Here you're looking for a repayment plan in case the creditors agree to take a haircut or somehow decide to let some liabilities go. That was the summary of how the process would happen. So in an insolvency process for an individual, in case the individual has some assets, then the creditors may choose to structure the insolvency process such that those assets can be maybe realized in time by the person, and then money can be paid to the creditors as part of a repayment plan. Correct me if I'm wrong there.
No, see, it's absolutely, absolutely fine. So I'm trying to say that the insolvency resolution process itself will take longer period, because there are 2-3 developments that has happened in the last 6 months. One, that earlier there was an order from Delhi High Court which said that when the RP will submit its report, RP will submit his report under section 99 of the code to NCLT, then the debtor will have a right to represent. The debtor will have a right to respond, and debtor will have a right to object. So that was the High Court judgment. So therefore, so earlier it was like the first hearing, the RP was being appointed by the adjudicating authority, and after that the RP will submit the report, and then there will be some adjudication, some objections from the debtor side, and then finally the RP would be appointed for the insolvency resolution process. So the first phase, which is the pre-resolution process stage, it was taking some time in the courts, and maybe that we can say that it is taking about 4 to 5 months or 6 months time, because a couple of hearings are in any case is required for adjudicating that part. But now there is a new judgment which is in the last week, where the ANCLAT has said that it should not be automatically that on just filing of the application, the RP is appointed. On filing of the application, there should be a notice should be served on the debtor. While the notice is served on the debtor, that means that the debtor's presence and that debtor's acceptance in the court that the notice has been served, that has also been made as a part of the process. So the pre-insolvency process is getting longer and longer. Pre-insolvency process is getting longer and longer. First, the application is filed. The ANCLAT has said that this has to be served upon the debtor. And once it is served upon the debtor, that means the debtor has a right to file a reply. And then finally, it would be adjudicated. So first process is the whether the RP should be appointed for a report under Section 99. Then the report would be filed. Then the debtor has a right to contest the report. And then finally, after the adjudication, the insolvency resolution process will start. And from that date, 180 days period will start. So the insolvency resolution process is getting longer. This is what is the first focus. Once this, and then only the bankruptcy will start. So insolvency resolution process is not something which is bad for the debtor, because it is just like a one-time settlement proposal, because in this process the repayment plan has to be submitted by the debtor. And however, there is no restriction on the debtor. While this insolvency resolution process is continuing, there is no restriction on the debtor. However, when the bankruptcy process will start, there are some restrictions on the debtor. So this is, I'm trying to say, this is important to understand that the application can be filed by the debtor. That means personal guarantor can also file the application, and the creditors can also file the application. So when the application is filed by the debtor, let us understand what is required. See, the application will be served on every financial creditor, and all the information would be, because it has to be a very complete application with the members of the immediate family, the particulars of the resolution professional, all the documents like income tax returns, wealth tax returns, statement of affairs, GST returns, bank statements, everything has to be submitted by the personal guarantor to NCLT while this application is filed. So the application, of course, the application can be filed by the creditors after giving a notice. However, in the case of debtor, there is no notice required. It is only service is required. Once the application is served on the financial creditors, the personal guarantor can file this application. Now, what I'm trying to say is that the application filing by the personal guarantor is a matter which can be done in a couple of days. If the information is prepared in hand, if all the income tax returns, whatever has been filed or not, that in case that is on record, that is something which is which should be ready for filing. Now, Section 96 says, the applicable to applications filed under Section 94 and 95, even if the application is filed by the debtor, personal guarantor, or the creditors, this interim moratorium is applicable. So interim moratorium in this case shall commence on the date of filing of the application. So interim moratorium shall commence on the date of filing of the application, and interim moratorium shall cease to have effect on the date of admission of such application. Now, the time between the filing of the application and the admission is getting larger and larger. So originally, it was considered to be a very, very small process. Now, because of the ANCLAT judgment, because of the Delhi High Court judgment, it is a process which even may take about 6 months' time or even more time, in case there are more objections or in case there are more people to object. So then, during the interim moratorium period, any pending legal action or proceedings in respect of any debt shall be deemed to have been stayed. The creditors of the debtor shall not initiate any legal action or proceedings in respect of any debt. Now, this is a moratorium. And there is no moratorium for the personal guarantor. There is no moratorium that he will not be able to sell his asset. There is no moratorium that he will not conduct any business. There is no moratorium that he will not repay any of the loans. So the moratorium here is only and only for the creditors, including the statutory liabilities, including the market creditors, including the income tax department, GST department. So this moratorium, in fact, some questions were asked to me in that seminar that this interim moratorium can be misused by the personal guarantors. So when I looked at the provisions, I also think that this can be used or misused for the benefit of some of the personal guarantors. Now, when we see that in various cases, some of the personal properties of the promoters who have given guarantee to the loan has also been mortgaged to the banks. In some cases, even the properties are only properties owned by the promoters are given to the banks, and the loan has been taken in the name of the companies. So in all those cases, presently, even if the company goes into insolvency, the SARFAESI action can be started. SARFAESI action can be started against the properties which are not owned by the company. So, Ankit, this was the question asked by various people there in the seminar, that if it is so, then the personal guarantor can file an application for his own insolvency and he can avail this interim moratorium, and the SARFAESI action can be stayed for some time. So when I looked at the provisions, I definitely could not say no to this, because yes, the provisions are such. The provisions are made with the intent of human angle, and it is basically the intent, if a person himself is ready for his own insolvency, then the creditors should wait, because the decision of bringing himself into insolvency is not a smaller decision. That means that the person is, because it has social impacts. So therefore, the law has been made in such a manner that yes, it can be, in fact, used for a stay against the personal properties when the creditors.
So I'm sure a lot of personal guarantors would have a guarantee outstanding against them, but they may not have any asset in their name. So for them, what is to lose if they apply for a bankruptcy or an insolvency process? They would rather come out of the process where whatever liabilities they had as a personal guarantor will no longer be there.
No, there are two issues, Ankit, what we are trying to pass on to our viewers today. One issue is that this interim moratorium, and the second issue is even the overall bankruptcy. Even the overall bankruptcy process is not detrimental to the interest of individuals, because this process is not as long as it used to be earlier. Now this bankruptcy process and the individual insolvency process both can be finished in 24 months. So therefore, what I understand, like 24 months and then thereafter, you are completely a fresh commercial person. You actually have all the rights to become director. You would not be, You're
back now.
I feel.
You're back now. Yeah, we just lost you for a few minutes, few seconds.
Am I audible?
You're audible now.
Okay. So then I'm actually saying that this is there is a different moratorium when this application is admitted under section 101, and this moratorium shall cease at the end of 180 days from the admission of the adjudicating authority or admission of or approval of the repayment plan. And this moratorium says any pending action or proceedings in respect of any debt shall be deemed to have been stayed, and creditors shall not initiate any legal action or legal proceedings in respect of debt. And I believe this includes SARFAESI action. Now, once this insolvency resolution process starts, now there is an additional moratorium which says the debtor shall not transfer, alienate, encumber, or dispose of any asset or any legal right or beneficial interest. So this has come now, and the time between the application and such admission is getting in larger. Getting in the larger means that since there are two processes which has been added by different courts, one by the Delhi High Court and the other by NCLAT, that even on the application it has to be served on the debtor, and secondly on the report which is submitted by the RP under section 99, the debtor has the right to object and have a. So this also one important part is that the rule 11 says that this application can even be withdrawn. It may be a debtor or by the creditor. It can be withdrawn before the admission on the request of the applicant. After the admission on the request of the application, if 90% of the creditors agree for such withdrawal. So there is, since there is no concept of constitution of committee, no concept of constitution of committee, no option to withdraw after admission without 90%. So application for withdrawal after the admission would be made in Form D of the rules. So fee and expenses should be paid. So even this application can be withdrawn. Now let us take an example that the application is submitted and there is a immediate stay on the SARFAESI action by the bank. Then in the meantime, the proceedings are going on in NCLT or DRT. And in the meantime, there is a settlement between the banks and the borrower. And thereafter, this application can be withdrawn also. So thereafter, the application can be withdrawn also. So that actually is kind of, it can be used as a stay. It can be used as a stay. So what I'm trying to say, this is, which is, so when I say the creditors, there is nothing that I could find. There is nothing that I could find that it is restricted to the banks or financial institutions. I could not find this provision that this process is restricted to banks or financial institutions. So what I understand is that this process can be even used by those people who have taken the personal guarantee of the promoters while giving their property on rent, or even it can be used by those people who have taken personal guarantee while supplying some goods to the company. So this also is very important. So when we see the list of creditors got no kind of bifurcation of banks and financial institutions. Number two, there is no bifurcation between operational creditor and financial creditor, and everyone is a creditor here. However, there is a bifurcation of secured and unsecured in this individual insolvency. So in individual insolvency, there is nothing like operational creditor, there is nothing like financial creditor. So the statement of affairs in any case, I'm actually trying to say this meeting and quorum and somebody voting. So these are all kind of the insolvency resolution process. And even in another case, even if a repayment plan is given, now the borrower has to give a repayment plan, and that repayment plan should be such so that the creditors should accept it. See, when I look at the provisions, the repayment plan can be given by the borrower. The repayment plan will be accepted by the borrower, and the repayment plan actually will have the implementation also. So in case the repayment plan is implemented, and in case after some time it is seen that the repayment plan is not getting implemented and the borrower is not able to make payment as per the repayment plan, then the ultimate impact would be that the bankruptcy process will start. Bankruptcy process will start. So once the bankruptcy process will start, so that's a natural outcome. Even if there is a repayment plan, and if the repayment plan is not implemented, or it is contravened, that means the bankruptcy process will start. And in case the repayment plan is not given by the borrower, by the personal guarantor, even then the bankruptcy process will start. So it is almost better, it is all the more better that the borrower should give a repayment plan. May it be bullish, may it be even in such a manner that it should be acceptable to the creditor. And then the repayment plan would be accepted, but would be accepted by the adjudicating authority. And if later on it is getting contravened, then only the bankruptcy process will start. Then only the bankruptcy process will start. Now, let us understand, in case of the repayment plan completely get, like maybe that there is a case, whatever kind of one-time settlement is agreed between the borrower and the bank, that will become part of the repayment plan. And then the discharge which will be given to the debtor, that will be only given to in relation to those debts which are mentioned in the repayment plan. The discharge would be given with regard to those debts only which are mentioned in the repayment plan. So that is also because see, like this repayment plan, and if some people are not taking participation into the insolvency resolution process, they can still proceed against the same person again. In case there is a repayment plan with, for example, as an illustration with State Bank of India, and that repayment plan says that the repayment will be done in 2 years, and the repayment plan is approved by the adjudicating authority, but during this insolvency resolution process, the Punjab National Bank did not file its claim. So the insolvency resolution process does not say that the Punjab National Bank will have no claim later on. So the Punjab National Bank can again come back and file another insolvency for this person. So the resolution, or unless the Punjab National Bank is part of that 25% who are dissenting, because it needs 75% approval for repayment plan. So in case they don't file their claim, I have not seen anything that those will be getting discharged. Those debts will get discharged. And it is because the discharge is only in relation to the debts mentioned in the repayment plan. So the repayment plan may provide for early discharge. That's something which is totally different. And during this insolvency resolution process, it is not the obligation of the resolution process to find out undervalued transaction, preferential transactions, or extortionate credit transactions. It is not the duty of the RP. It is the duty of the bankruptcy trustee in the bankruptcy trust in the bankruptcy process. So the RP, so this process of insolvency resolution process is very, very comfortable process. It is not really difficult for any individual. So it is a boon for them, because this will actually give them some time to negotiate with the banks. It will give a moratorium to them for negotiating with the banks. They would, the banks will also start thinking of a settlement process. So this is not a difficult process. So I would see that this is a boon for the personal guarantors, and this way they can restart, they can reset their life, their commercial life. So this is the focus. This is the focus now. That is the reason that we are saying that we should now go to the bankruptcy part of it. The bankruptcy, we actually had wanted to start. I'll just take out a few things, because this is the punishment, all that we will come out later. But now I will go to the other slide that we have prepared for the bankruptcy of the personal guarantors. So
let's take a few quick questions. Deepaji is asking whether the resolution professional appointed can be replaced at any stage. I believe they can be.
No. There is no provision of replacement of RP. Yeah, there is a possibility of making an application, like even the even the debtor can make an application, or the creditors can also make an application to the adjudicating authority that they are not comfortable with the existing RP. He is not performing or he is conniving. There has to be a case.
There has
In
to be a
case
reason. There
there
has to
has
be
to be a reason for
non-performance
replacement,
or
and they don't have. See, in case they ask for a replacement, then they don't have a choice of recommending their own RP.
so the
So
RP
once
will be chosen
then
randomly.
RP will be chosen from the panel which is maintained with NCLT. So in this
But
case,
the RP's choice is there with respect to the initial application.
yes, initial application, the RP's choice is there. Even the RP's, even if the RP is appointed by the debtor,
Even then, the RP will remain the same.
Even then, the RP will remain the same.
And the
Even if
creditors
the
have
RP,
no option but to replace the RP.
The creditors have an option, but they will have an option to get anyone else appointed from the panel. They have no option to recommend.
And there again, they will have to say that there's some connivance, there's something wrong with what the RP is doing with respect to that person.
Yes.
Okay.
So
then in that case, for an insolvency professional, somebody who wants to become
one scenario, like in case of a repayment plan, when a repayment plan is approved, there is a possibility of a repayment plan that in the repayment plan, the scenario is such that the borrower will conduct his business, the borrower will do such activities, or the borrower will get some rental income. Out of that income, there will be some part which will be given to the creditors in a period of 2 years or 3 years. For that monitoring purposes, the creditors has powers to replace the RP, and it requires 75% of the voting power. However, during this insolvency resolution process, there is nothing that there is no requirement of any change of the RP, because the role of the RP is very, very limited. It is primarily the receiving claims, accepting claims, preparing a list of creditors, preparing a report under Section 99, then preparing the statement of affairs of the debtor, then asking for the repayment plan, helping the borrower to prepare a repayment plan, calling the meeting of list of creditors, getting the repayment plan approved. If it is approved, submission to the adjudicating authority, and that's what is the total. And submission of a report of the meeting of the creditors, submission of a report on the repayment plan. So these are the only duties. So hardly there is any possibility that the RP can do something better or something wrong to any part of the stakeholders. So therefore, there is no provision of replacement of RP. And if it is there, then it has to be done by the adjudicating authority, and there is no choice of recommendation of name. As you recall, Ankit, like my name was selected for RP of Anil Ambani. And however, the application was submitted by State Bank of India. And in that application, they did not get my signatures. The adjudicating authority said that if you have to recommend an RP, you have to recommend a RP, then you have to get that application signed. And there is no possibility now that you can get that application signed. So they picked up a name from the panel. After that, the State Bank of India is struggling to get it replaced, but there is adjudicating authority saying that there is no provision of replacement. So there is no provision for replacement. If there is a provision for replacement, then they will pick up somebody else from the panel. So there is no power with the creditors to replace the RP. So what are the other questions?
So next we have a question from Kushwinder ji. He's asking that if the CD has already been admitted to CIRP and the successful resolution applicant has taken over the CD, still there are certain proceedings under SARFAESI going on against the promoters of that company. And now he's saying that can those proceedings under SARFAESI be stayed through if the promoters are personal guarantors? I believe the answer is yes. I think this is a very well-suited case. Yes. Where the promoters can actually go for individual bankruptcy, maybe make an application for their own for their own insolvency and bankruptcy, and then but the only case scenario here is that in case the idea is to protect the property and not allow the banks to sell it or So they can easily sell it through under their own control through the repayment plan. That's one option. And of course, under bankruptcy also, in case the value of the asset which is being targeted under SARFAESI is less than the outstanding balance, then they can even get a waiver and they can then start life afresh. Any other thing that you think that something else that?
No, you are absolutely right. The resolution plan has been approved. Company has been taken over by successful resolution applicant, and the banks is pursuing their recovery from the promoters from their personal properties, which are mortgaged to the bank or which are not mortgaged to the bank. So this is a fit case that the personal grantor, the promoter, he should immediately file an application under section 94 of the IBC for individual insolvency resolution process. And even immediately after filing the application, he would be protected under the moratorium, and the banks would not be able to take any coercive action, no proceedings, and would be initiated against that borrower.
So legally speaking, who can fund the insolvency process for the individual person? Can the individual himself fund it? Is it legally allowed?
I have carefully seen, even I have seen that the creditor who is filing the application, the applicant has to bear the cost. There is only one provision that I could see, that in case of a repayment plan, the repayment plan first must provide for the resolution process cost. The repayment plan first must provide for the repayment process cost, even if the same has been spent by the creditor. If it is spent by the debtor, then it is not required because he already might have paid. And if it is not paid, then it must provide for that. So the repayment plan is the only thing which asks for the resolution process cost, including the fee of the RP, including the fee of the professionals, lawyers, whatsoever expenditure has been, that everything has to be paid from the repayment plan. So in case there is nothing, in case there is no repayment plan, then the applicant will pay that. If the applicant is the personal grantor himself, he will pay. If the applicant is the creditor, then he will pay. Since there is no concept of committee of creditors, there is no concept of approval of resolution process cost by the creditor. It only requires the approval of the applicant. Like in case the State Bank of India has appointed us, the State Bank of India will give us the fees, not the other creditors. Even if they file their claim, but the other creditors are not supposed to make the payment. However, in case there is any repayment plan, then from the repayment plan, the first part which will out to go, that would be the resolution process cost. Similarly, in the case of the debtor appointing the RP, debtor initiating the application, debtor filing the application, then the debtor will bear the cost. And in the repayment plan, if there is any unpaid portion, that has to be taken care of. And that would be the first payment which will be made by the debtor.
Right.
So this is actually, I'm trying to say that like this is more beneficial to the personal grantors. This entire process is more beneficial to the personal grantors, even if their company is not under insolvency, even if their company is all the assets of the company has already been liquidated, even if the resolution plan for their company has already been approved, even if the banks have taken over all the assets of that company under SARFAESI Act, still, if the banks are proceeding against individual grantors, then the individual grantors can take benefit of this law by filing an application to DRT in case their case is not under insolvency, in case their company is not under insolvency.
So individual guarantors to a corporate debtor can go for the insolvency process, for the bankruptcy process at any stage whatsoever. There is no limit at all. So as long as their guarantee has been invoked or there has been a default in the debt which has been guaranteed by them, they can go to the DRT or NCLT and get their process started. It doesn't matter if the company has gone into CIRP or the company has found a resolution plan or the company has gone into liquidation. The stage does not matter.
that stage, see, I'm not even talking about this stage. I'm even talking about those cases which are even prior to the insolvency law. Like, look at, there are some cases that we know that the company was NPA in maybe 2012, and the banks have recovered all their properties which were in the name of the company. Now the banks are proceeding in DRT against the personal guarantors. Now those directors are not able to do any business in their own name because they are defaulters, because the banks is proceeding against them in DRT to recover money because of their personal guarantee. I know very many cases where the directors are actually getting proceeded against, and they are presently struggling because they are not doing business in their own name. So for them, it is important that they should take benefit of this law, and they should start their commercial life afresh. They should take the benefit of this moratorium, and in this process, they will settle with the banks, and the banks will come on the closure. So this is a closure process of their default phase. This is a closure process for their default carrier. So this is what I'm trying to say, that this law is basically for giving a fresh start to those people who have not done any fraud with the banks, who have not raised any debt with fraud from the bank. So it is only applicable to those cases where there is no fraud pending against them.
All right. So in that case, then the personal guarantors who are eligible in this scheme can then very well, we have understood that he can apply for this process and also bear the cost by himself or herself, and the individual, the RP will then get the fee in that case. Because I think what we are seeing is that a lot of cases which the banks are doing against guarantors, the realization of the fee is also difficult in absence of any assets. So I believe when somebody is working for a personal guarantor and filing the case on their behalf, then of course all these things will be different. The money would ideally be there for that person to pay up and say that, okay, I want to be now a discharged insolvent so that I can start my life again.
Yes, and since there is no committee of creditors, so therefore only the applicant has to bear the cost, and that is the only reason why the banks are so apprehensive about the total cost of insolvency resolution process, and they are not giving much fee because it is their own expenditure. Unless the repayment plan is submitted by the debtor, then only they will be able to recover that kind of money from the debtor. Otherwise, it is their own expenditure.
Right.
And it is even not being considered as an interim finance. It is considered as a cost to applicant. And in case it is recovered later on from the repayment plan, then it will be a recovery for them.
So any difference between secured, unsecured creditors? Like when we look at, of course, the insolvency process, we are seeing that the secured, so do they have a different status? Or is it the same logic that is in CIRP, that you have a creditor who has a security interest, so you would give them at least that much amount that is due to them, or the value of the security, and then in the liquidation again, then you give them a preference. So it's the same process.
See, Ankit, there is like, as far as the list of creditors is concerned, there is no difference. All creditors are having voting power.
The water flow is
waterfall
different.
is different.
Waterfall is different.
Waterfall is provided in section 178 of the IBC, which is for individuals, and that waterfall, I'll just show it to you. But then as far as this list of creditors is concerned, during the insolvency resolution process, there is no difference between the operational creditors or financial creditor. There is no difference between the secured creditor or the unsecured creditor. However, when the creditors are filing their claim, they have two options. One option is that they forfeit their right to proceed against that security interest, and they file their claim, and then their total claim will be considered by the RP, and accordingly a list of creditors will be made, and that loan will be considered as secured loan to the extent of the value of their security. Second option is that they submit an affidavit that they submit an affidavit that they will proceed against the enforcement of their security interest, and they are only filing the claim for their balance amount, which will be considered as unsecured loan. And they will participate into the process only for that unsecured portion of the claim. And this particular estimate of what is the value of the security interest, that will be based on some rationale which will be provided by the secured creditor, and that will be verified by the RP. Maybe a valuation report or some other relevant information about the value of that security interest. And in this section 178, when we look at the waterfall arrangement, the first priority is the resolution process cost or the bankruptcy process cost. Second is pari passu with the workman and the secured creditor. It is similar to section 53 of the IBC, which is relevant to corporate debtors. Then the third is the salary of the employees. Fourth is the all statutory obligations of the person. And the last is the all operational creditors and unsecured creditors. So there are only 5 priorities. So there is no preference shares or there is no equity shares as we see in section 53. Section 178 is only and only for these 5 things. And primarily, I can see that this money would be payable to the workman in case there is any workman for the individual. And this has got nothing to do with the workman of the company, because this particular law is applicable to all the affairs of an individual. Presently, it is applicable to only the personal guarantors. However, even if a personal guarantor has got a proprietorship concern, even if a personal guarantor has got a partnership firm, those also will get impacted. So that personal guarantor will, the entire law will be applicable, and his proprietorship concern and his other partnership concerns and his and other shareholding will also come under this process. Yes, Ankit, in case there are some questions.
I think you can continue, and then we will take up some questions after
so we,
another 5-10 minutes.
Since we have made a background that why this insolvency resolution process. So the bankruptcy is something that all these individual insolvency resolution process will lead to bankruptcy process. So therefore, it is important for all of us to understand what a bankruptcy process is, how difficult it is, how important it is, and what actually finally will flow in from the entire process, and how much time it takes in providing that fresh start status to humans. How much time it takes to provide that fresh start to humans. So this particular slide is only on the bankruptcy process. So the bankruptcy process, as I said, this is first of all, the application for the bankruptcy. This is under section 121 of the IBC. So the one thing is very clear. I would also be differentiating because most of the participants would be having some experience of corporate insolvency resolution process. So Ankit also will do one thing, that we will not exceed from 1 hour. It will be only restricted to 1 hour. And even if the bankruptcy, we are starting, because see, we have given a background, and the bankruptcy, of course, because we are doing a clause by clause discussions on the bankruptcy. So it might even further expand into one more episode on the bankruptcy part. So like today, we are actually saying that the bankruptcy process cannot be started automatically, unlike liquidation process. In case of corporate insolvency resolution process, in case the CIR, in case there is no resolution plan, then the company goes into liquidation. However, in case of the insolvency resolution process, in case there is no repayment plan, and then the bankruptcy application is not automatic. Bankruptcy has to be filed. Another application has to be filed. It can be filed by the creditors individually or jointly with others. or it can be filed by the personal guarantor or the debtor, whatever we may call, and both can file the application for bankruptcy. It is not really important who was the original applicant. It is not really important who was the original applicant. Even if the original applicant was a bank, and after the individual resolution process, the banks feel that there is no asset with this person, so there is no point going to the bankruptcy and spending money on the professional. So the bank may not think of filing an application for bankruptcy only to save the money, only to save the cost. However, as far as I understand, the central government, the government is definitely interested that all those people who have caused losses to banks, they should be declared as bankrupt. So, however, the banks are the public sector banks, private sector banks, they are considering this as a cost to them. So, however, even if the banks are not interested in filing the bankruptcy application, then also the guarantor himself can file his own application for the bankruptcy, irrespective whether the original application was filed by the bank or by the debtor himself. So what are the circumstances when such application of bankruptcy can be filed? First, in case the application under section 94 or 95 is considered fraudulent under section 100, because subclause 4 of section 100 says that there are certain circumstances that the application would be considered as fraudulent. Second, when the repayment plan submitted under section 114 is rejected by the adjudicating authority. Third, no repayment plan approved by the creditors or no meeting of the creditor is summoned by the RP, and the adjudicating authority passed the order based on report of the RP. So in this personal insolvency resolution process, there is a scenario that there is no repayment plan. The debtor is not interested in submission of a repayment plan. The RP decides that the meeting of creditor is not required, because the why meeting of creditor is required only and only for approval of a repayment plan. So if there is no repayment plan ever submitted by the debtor, then why to have meeting of the creditors? So in that case, the RP will submit a report that why the meeting of the creditor is not being summoned. There is no objective, there is no agenda. So the RP can even conclude that during the insolvency resolution process, there is no repayment plan, so therefore no meeting of the creditor is called, and he can submit a report to the adjudicating authority. Fourth, I'm actually saying that under what circumstances the bankruptcy process can be started. Number one, the application is fraudulent. Number two, the repayment plan is rejected by the adjudicating authority. Number three, there is no repayment plan and there is no meeting even. Number four, the repayment plan approved earlier has not been implemented completely, and an order has been passed by the adjudicating authority that this resolution repayment plan is contravened. So in all the above cases, the application shall be filed within 3 months from the date of the order. First order, fraudulent order. Number two, 1152 order, like the repayment plan is rejected. Number three, 1183 order, that the repayment plan earlier, which was submitted and which was approved by the creditor, is contravened. It is not implemented, 1183. And fourth is that on expiry of 180 days, no repayment plan was submitted, and the report of the RP says under section 114 that the meeting was not called. Therefore, the resolution process ends. So these are the 4 circumstances when the bankruptcy application can be filed. So I think, Ankit, if you see this, any question comes in your mind at this level, even if it is not asked by the audience today.
No, I believe that's okay. So I've understood that in what circumstances the bankruptcy will happen. It is very normal now that, it is very logical that if a repayment plan has been passed, then bankruptcy should not happen. I think that's the basic idea. And then allowing either of the two parties to file for bankruptcy is, I think, the law's intention is that if somebody is having liabilities, does not have enough assets to repay them, is not able to bring in a repayment plan, then that person can go through the bankruptcy process, and after that his liabilities can be again come back to zero, so that he can start life afresh. Otherwise that person will be fighting cases and paying his debts throughout his remaining life. So a reset has been made available to that person. And therefore, now I believe the bank's policy to start a bankruptcy process against any individual who has given a personal guarantee against a corporate debtor should stop, and it should start only where the default has just happened uh, at the CIRP at the CD's end, and where the bank feels that maybe some part of the assets which were part of the net worth statement, which may not be mortgaged to some other financial creditor, are available with the uh, guarantor to repay the debt. So speed is of course essential there. If a bank waits for say 4 or 5 years after NPA and then goes behind the individual, then most probably he has already planned his insolvency.
So, see, you're right, Ankit. Now, I think we have now seen under what circumstances the bankruptcy can be filed. And if that is clear, then we can spend some more time in the application, which can be filed by the personal guarantor under section 122. So there is a form A under rule 6, application fee is only 2,000 rupees. However, the one copy of the application will have to be served to every creditor, and every creditor means those who have submitted their claim or as per the statement of affairs provided by the debtor, uh, and also to that corporate debtor where this individual has given guarantee. Then the application, see, like the application by the debtor himself is little lengthy, because it also requires complete information about the debtor himself. So what are the documents required? All records of insolvency resolution process, including all orders passed by the adjudicating authority, and copy of the application under section 94 or 95. Then all documents evidencing existence of debt and default. Then income tax returns, computation of income, bank account statements, personal guarantee contract, statement of affairs made up to 2 days from the date of application, up to 2 days. Statement of affairs made up to 2 days from the date of application, details of statement of affairs as per form A, and there is a form A for making statement of affair. Ownership and title documents of all the assets, various other documents as per form A. Because there was lot many. So when we prepare an application, this is going to be a very lengthy application, so it may even run into 1,000 pages. Then in this case, the debtor also may propose an insolvency professional as bankruptcy trustee. In the application, debtor has the power to appoint IP. Debtor, however, after filing this application, he has no rights to withdraw the application. He has to file the application to adjudicating authority, and the adjudicating authority can only allow that. So this similarly, the application can also filed by the creditor, and there is a form B under rule 7. Application fee is the same, 2,000. Again, the creditor will serve a copy of the application for bankruptcy to debtor and the corporate debtor to which he has given a guarantee. And the creditors can file this application jointly or individually. However, they can nominate one amongst themselves to do everything and to sign on all of them on behalf of all of them. The application shall be accompanied with following documents and will provide following information, like all records of insolvency resolution process and copy of application under section 94 or 95, copy of the order passed by adjudicating authority under chapter 3, all documents evidencing existence of debt and default, income tax returns, computation of income, bank account statements, personal guarantee contracts, statement of affairs made up to 2 days from the date of application, ownership and title documents of all the assets, statement of secured creditors under section 123(2), and in case this, like as I said, this statement means that the kind of whether this secured creditor will relinquish the security interest to the bankruptcy trustee, or the application can be filed only for unsecured part. That is something which is section 123 subsection 2 says. So when the creditor is filing an application for bankruptcy, he has to choose option 1 and option 2, as we discussed. The creditor may propose an insolvency professional as bankruptcy trustee. So
the bankruptcy trustee or the insolvency professional also, which can be proposed by the creditor or the debtor, can that person be can that person be already be the RP of the CD where the default has happened? There is a bar on that, right?
No, there is, sorry, which one? Like any IP who was...
The eligibility of the RP, in that eligibility criteria, one eligibility criteria is that he should not be the RP of the corporate debtor.
Yes, that is continuing.
That is there. Or
also
there. Or also the IPE association should also not be there, if I'm not wrong.
No, that is not restricted.
That is not restricted.
That is not restricted. So
there
has not been any case where it is. So it can't be the same person.
Can't be the same.
However, the RP for resolution process and the RP for bankruptcy process, trustee process would be the same.
Yeah, that's fine. So I think we have passed 5. So we have passed 5, and I think
it's only one thing that we have.
Wind this up.
Yeah, we'll just wind up in 1 minute. So there have been a couple of orders from NCLT where they have said that in case the grantor is expired, in case the grantor is deceased, then no action can be taken against them. However, it is clarified in the law that the application for bankruptcy in case the debtor is deceased can be filed against his legal representatives. So this, probably the lawyers who was representing this case, they have not informed the relevant law. So the NCLT has given 2 decisions that it is not applicable to deceased.
So however, in that case, the asset should be there, right? Which is
it is only against the against the estate of the deceased.
Yeah. So if there is no estate and if there is only liabilities, those liabilities will automatically be understood to be waived off.
Right. So we stop here, and we will just see that we are only, as we have only attended applications, and then we will start with the interim moratorium on the next Sunday at 4 p.m. So this, I think we will not extend more than 1 hour. Otherwise, it becomes boring. In case there are any questions, Ankit, in the chat box that you can see.
So there are some questions, but they're not directly linked with the personal insolvency process. That's why I have not taken them up. I think we can always take them up separately. So if there are any questions from any of the participants that we may not have been able to take up, then they can approach me and we can take up those questions separately.
So this bankruptcy process is is very important because the individual insolvency is going to stay in this country. Presently, it is only applicable to personal guarantors. However, the law that we are deliberating today is applicable to all the individuals whenever it is notified. There are not going to be 2 laws. It is the same law which was made for individuals. However, it has been notified only for the personal guarantors so far. The individual insolvency is going to come in the country, and that may come in another 2 years' time. But yes, the bankruptcy would be a very, very important part under the individual insolvency. Therefore, or secondly, unless we understand bankruptcy, it is very difficult to handle individual resolution process also, for which even more than 1,000 applications are already before the adjudicating authority. Secondly, this individual insolvency process can be used by all the defaulting persons who are presently tagged as defaulters. They can actually get their life reset. They can claim their commercial status back, and they can be fully entitled to become director, do business, own properties, and they can live their life in a very, very commercially very, very high. Thank you very much, participants. We'll be back on next Sunday, 4 p.m. with the rest of the part of the bankruptcy. Yes, over to Ankit.
Thank you, everyone. Thank you, everyone. And see you next Sunday. Thank you for today's participation. Looking forward. Thank you.
Thank you.